This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Hello and welcome to the Financial Podcast. My name is Gary Poyer. The Financial Podcast is brought to you by Customplan Financial Advisors, an award-winning managing general agency that provides exceptional support and resources to the independent financial advisor. Please visit customplanfinancial.com to see all the resources that are available to you as an independent financial advisor. Today, we'll be looking at some of the legal issues associated with estate planning. In other words, we're going to be talking about estate planning litigation issues. And I'm happy to say that we have with us lawyer Paul Reid. Welcome, Paul.
Hi, Gary.
Paul, why don't you tell us a little bit about yourself?
Okay, so my name is Paul Reid, and I am a partner at Carscallen LLP, which is a full-service law firm located in Calgary, Alberta. We are a Calgary-based firm, born and bred there, and we only have a presence in Calgary, so we certainly cater to that market, and we're happy to be part of the Calgary business community.
Right on. And how long have you been a lawyer?
I was called to the bar in 2014. I've always done litigation after I completed my articles, and the first 5 years of my practice was focused on primarily Aboriginal rights litigation. I moved firms. I ended up moving to Carscallen and fell in with Jennifer Lamb, who I believe you've had on your show. Mm-hmm. And the wills and estates litigation just seemed to be a really good fit, something I took to very quickly. And now I'd say it's about 80% of my practice. And then the balance of what I do is, commercial civil litigation, as well as still some Indigenous law.
Okay, well, sure, it's very interesting. I'm sure you come across a lot of different scenarios. Is there one reason or one cause that wills end up in court?
Planning, poor planning.
Yeah.
That old saying, failing to plan is planning to fail. I think in the wills and estates context couldn't be more true. Yeah,
I guess so. As a financial planner, I always find retirement planning and estate planning to be the most interesting aspect, because you're looking into the future. But I think a lot of people, for whatever reason, they don't want to talk about death or their own mortality. So maybe they don't either make a will or make it very clearly. But Paul, I think what I'll do is maybe we'll talk about some different scenarios, and I'll present the scenario to you, and you can talk about it. And if you have any examples that you can provide, that would be great. And the first scenario I'd like to kind of mention is holograph wills. Now, most of us understand that a holograph will is a handwritten will. It's dated, signed by the testator, but with no witnesses. So what about the situation where I don't have a will, but I write a letter to my niece saying that I just had my piano tuned and I can't wait for her to come and play it because I know how much she enjoys playing on my piano. I then die. Is it possible for my niece to use that handwritten letter as a form of holograph will, at least when it comes to the piano?
So that's a great question. We see this enough. One of the things that you need to remember when you're dealing with a will is that it has to be done with testamentary intent. So the person who's preparing the will needs to be doing it with a disposing mind in contemplation of death. Mm-hmm. If you were to write a letter like that says, I had the piano tuned and I know that you love playing the piano, that certainly doesn't show that you have testamentary intent. I think that would be lacking. That being said, anybody can always try to make a claim against your estate on sometimes shaky bases. One thing you had said, and I think a lot of people have a misconception, under the Wills and Succession Act, the holograph will just has to be a will wholly in the testator's own handwriting and signed by the testator. It doesn't have to be dated. That's not a requirement.
All right.
So I've run into this before. We had a multi-day trial with a holograph will that was handwritten. It was a package in a series of notes that was found in a china cabinet. It was written in a Italian dialect by a woman who was very hardworking and very intelligent, but she hadn't completed elementary school. She had immigrated to Canada. She wrote this series of letters. She didn't date them, and she did say, though, what allowed us to have this validated was the fact that she said she clearly wrote it in contemplation of death. She said, "This is my will." And then she went on to say how she wanted to deal with her property, perhaps not in the most clear fashion possible, but everything to so-and-so, and that's how it would go. And then she signed it. And funny enough, she even continued to write after that, which, the other side wanted to suggest was fatal to that being a holograph will, because there was further messaging after. However, on the strength of the document alone, the court was able to find that was in fact a holograph will. We were able to construct a timeline based on some of the content she had put in the will, in terms of where she was in her life. So we knew that her husband had passed away after a certain date. She had made reference to her husband's passing. We knew that then made this holograph will subsequent to her formal will that she had drafted many years earlier, and we were able to validate it on that basis. So, I wouldn't encourage people to make holograph wills. They're available, to the public and to anyone who wants to create one. But it should be seen as kind of an emergency or stopgap measure, right? In a situation where you just can't get in to see your lawyer, or you find yourself in a difficult situation. Perhaps you've just had an accident. You're on the road somewhere, and you're not sure if you're going to be able to get medical attention in time. Something like that. Mm-hmm. Perhaps that's the situation where you may want to put down your wishes, but it has to be wholly in your own handwriting. So using one of those will kits isn't going to assist in creating a holograph will if that's deficient, and signed by you. And dating is a good idea. Certainly helps, because if there are competing wills, that will show that that's the most recent will and the will that should be upheld.
Yeah. It almost sounds like you have to be maybe a bit of a detective. With holograph wills, if there's no date, you sort of have to piece things together and do some detective work. Yes, certainly. And I wouldn't recommend that people, take that route unless they absolutely have to. Again, it's there as more of a stopgap. It shouldn't be something that's relied upon, because you are going to want some professional advice when you're preparing testamentary documents. Yeah. I mean, sometimes in the movies or on TV, you see somebody, on a bus going to some places writing his will out. So, otherwise, legal advice is probably the best route to go. What about, I understand that an executor can seek outside assistance when winding up an estate. So, an executor can bring in an accountant or a lawyer for some guidance. What about the scenario where the executor goes and has the final tax returns done with Myers Norris Penny, for instance, and one of the beneficiaries says, well, "Why did you spend all that money? I could have done it just by using a tax program on my computer." And the beneficiary then makes a claim against the executor. Can a beneficiary do that? Is there what legal recourse would a beneficiary have, or what legal protection would the executor have? Okay, so executors in Alberta, they're referred to, I guess, both interchangeably as executors or personal representatives.
They are defined as personal representatives under the legislation. So I may use both terms interchangeably. Personal representatives have a duty to account to the beneficiaries. So at the end of the day, there needs to be a reconciliation. There's a certain form prescribed under both the legislation and the surrogate rules that says this is how you present your accounting. And when they do that, which they are required to do every 2 years and at the end of the administration of the estate, sometimes you'll have a beneficiary who says, well, why did you spend $30,000 on a national accounting firm? We didn't need to do that. This was a simple estate. The personal representative's standard of care, and are you familiar with that term? Standard of care? Yeah. Okay. So the personal representative standard of care is to exercise the care, skill, and diligence of an ordinarily prudent person. Okay. And they're also able to rely on the support and help of professionals in administering an estate. And obviously the test of what an ordinarily prudent person would do, it changes with the facts and circumstances. But as long as you're doing something that most people or even half the people would do, you're certainly well within that standard. I wouldn't be concerned when you're relying on professionals that they're, if the account at the end of the day is going to be quite high, I think as long as it's still within the realm of reason, the personal representative shouldn't have to worry about having to reimburse the estate. That being said, if you have an estate of very very meager means, it may make sense to consider whether a reasonably prudent person or an ordinarily prudent person would go about hiring something that may strip the remaining assets out of the estate to perform an accounting.
Right, that makes sense. What about this? What about this scenario where a grandfather has a will prepared, but in the will he doesn't clearly define what grandchildren means. So let's say that he's got some natural grandchildren, maybe some adopted grandchildren, and maybe some blended family grandchildren. And the natural grandchildren go to court saying that grandpa just meant the natural born, not the adopted ones, for instance. Have you ever run into a situation like that?
We have. And like we had discussed at the beginning, that's something where planning is very, very important. If you have a blended family, you don't want to be using generic descriptors like grandchildren. And if you come and see professionals, they're going to say, okay, I see a potential problem down the road. Let's name them. It's simple as that, right? Mm-hmm. And then you can go about specifying who gets what, and there'll be clarity. Oftentimes, we see in our practice, if there's sloppy wills or wills that have questionable language or unreasonable bequests, the court says, you know what? The deceased bought himself a lawsuit. And guess what? It's going to be the estate that's paying for all this litigation that happened as a result. So that type of situation is one where it really comes down to planning. And when you have, especially a blended family dynamic, it couldn't be more important.
Yeah, I would think that that can get really messy. Like break up families, grandchildren, turn on one another. It just seems like whenever money's involved, people's personalities change for whatever reason.
Certainly, and I think for the small upfront cost of having a professionally planned and prepared estate plan, the cost of litigation is can be very, very heavy. It can, like you said, destroy families. We've seen so many instances where you had this family that was functioning fine before, and there might have been a bit of what we call sandbox stuff back when the kids were younger, and that starts bubbling to the surface. And I remember a particular estate where there were two sisters who were fighting over effectively a difference of $40,000. and the estate was much larger than $40,000. And the judge said, you know what? We're going to distribute the entire estate. I'm going to put your $40,000 aside, and then you guys can, quote unquote, blow your brains out litigating over this. Because all he could see was the wastage to the remainder of the estate. And he wanted them to put some skin in the game and understand that, you know, you're really being quite petty here when it comes to the amount at issue, given the size of the estate. But you're using all these estate resources to fight your battle.
Yeah. You know, you mentioned about, sandbox issues. And I think that probably happens a fair amount where, something that happened years and years ago kind of comes back and resurfaces during estate planning litigation situation. It's like things fester in your mind and come about at most opportune time. Well, what about where there's more than one executor? Say an even number of executors, 2 or 4, and the executors just can't agree on a course of action when winding up the estate. What happens in that situation? How does the judge resolve that situation?
So I'm just going to say, on the planning side, whenever I do a bit of planning as well, whenever somebody tells me that they want to treat their kids fairly, I say, great, give them each a fair amount of the estate. And then what they also seem to want is for me to also agree with them that 2 or more children should share the executorship duties. And I always advise my clients to pick one. They don't always follow my advice, but that's the cleanest way to administer the estate. It's a lot easier if you put one person in. I am dealing with a situation right now where there's multiple executors, more than 2. Mm-hmm. And those siblings are having a really hard time making decisions, a really hard time getting along. It would be a simple estate if there was one executor. It would be a very straightforward path. However, that's not the case. And for whatever reason, and perhaps the testator had received advice that this wasn't a great idea, but said, you know what, I need to make sure that my kids feel like they're being treated fairly. But at the end of the day, if they don't, if they're not going to get along and if they're going to waste your legacy, then it's really not worth it. And in terms of the court process, though, when you do have, executors who can't get along, they can make an application for advice and direction to the court. That's the typical way that you would go about doing this. And the circuit court and justice will do what they can to try and assist with that issue and get them past that impasse. That being said, it's not a great use of court resources to have to settle family issues. And I think you do note from time to time when it's something that the siblings or the executors could resolve for themselves and they find themselves in front of a justice, they often are kind of shaking their head saying, well, we're all adults here. We should be able to work this out. You shouldn't be here. There's more important things for the court to do than settle your sandbox stuff.
Yeah, for sure. It's my understanding that when somebody dies without a will, somebody has to go to court, get letters of administration, I believe it is. Have you ever run into a situation where more than one person has gone to court wanting to wind up the estate for someone who doesn't have a will?
Yes. I'm dealing with that right now, where there's 2 people who claim that they have priority to administer an estate. There is it's legislated, the priority in which people can apply. It's spouse, children, grandchildren, and the list goes on and on. Eventually you end up in brothers and sisters, back to parents, then, even to claimants. So visa, if nobody else is there, could make that application if there's enough money on the line and say, look, we want to administer the estate because this person owed us $70,000 and that's us. Only if there's absolutely nobody does the government ever step into that breach, and they're the last on that list. So I think it's especially important for people who maybe don't have family and it's just them, to make sure that they do get their affairs in order, and certainly appoint those friends or whomever it is who they want to look after their affairs, because otherwise you don't want to have Visa or MasterCard deciding how your estate's going to be dealt with. That's certainly not something you would want. And then that's very unlikely, but that's kind of the list of priority, because the government doesn't want to step into that gap, and only will in the most unusual and rare of circumstances.
Okay. What about the situation where there's a beneficiary, the executor just cannot find the beneficiary, they've searched and searched and searched, and then, so I guess what happens in that situation? If somebody's supposed to receive a sum of money, but the beneficiary can't be found, what happens to that money? So
the court will, they can be declared, if they're missing and they cannot be located, they'll be declared dead. If they're declared dead, then it will be based on the operation of the will, if there's a will. Okay. So it'll be divided however the will allocates those funds amongst the remaining residual beneficiaries. And if there's no will, then it'll follow the legislative scheme as to how it'll be distributed. That's typically how those types of things work. I have had, a few matters where I've had people declared deceased, and in those cases, everything was just distributed amongst the remaining residual beneficiaries or the remaining beneficiaries pursuant to the legislation.
Okay. Now, what happens if so that person's share of the assets are distributed? What happens if the person then shows up and says, "I'm here, I'm alive, I want my
back from the dead"?
Is it too late?
This is the Lazarus scenario.
Yeah.
So in that instance, if there were funds remaining in the estate, potentially they might be able to obtain a share. But I think that would be highly dependent on there being funds remaining. I don't think that a Lazarus type claimant is going to be able to bring is going to be able to bring a claim against the personal representatives in that instance, because they would have done everything they could to locate the individual. They would have done what an ordinarily prudent person would have done. Perhaps they may have even gone to the court for advice and direction. At that point, I don't think there'd be any recourse against them personally. In the ordinary course, executors can be liable for missteps in the administration of the estate. They can be personally liable for taxes, for example. But had they gone through all of the steps necessary to try to locate the individual, they can't find them, they're declared dead. I would think in that instance, it'd be hard for them to come back at the executors to say, you know what, you didn't do your job, because this person would have been missing for, I suspect, a significant amount of time before they reemerged.
Yeah, I think I'm just thinking, somebody hopped on a boat, became a crew of a ship, sailed away to Africa for a few years, returned from here. But
yeah. Well, and I guess the other thing I would say is that once the accounts have all been passed, either formally or informally, and the executors have been released, and there's really wouldn't be much recourse at that stage.
Okay. All right. Okay. What about the situation where a person isn't in the will but feels like they should be a beneficiary? I'm sure this happens all the time. So what recourse does somebody who's not in the will as a beneficiary have? How do they go about challenging the will?
Well, there's different ways that a person could challenge a will. It would depend on the circumstances. So the nature of the beneficiary. An adult child who isn't dependent on their parent, in all likelihood, should just suck it up and move on. In British Columbia, for example, however, they would very likely be able to make a claim against the estate, and with likely some level of success. Here in Alberta, that would be unlikely. Somebody who's a wage earner, who doesn't have a disability, who's looking after themselves, and is just, if they just feel upset about the estate plan and being left out, then then that would kind of be a too bad, so sad situation. However, if you have someone who's a family member, who's dependent or a spouse, they can make what's called a claim for family maintenance and support against the estate, to make sure that they're looked after. And I don't want to say it's akin to calculations upon divorce, but of a similar vein. Mm-hmm. And we've had dozens and dozens and dozens of family maintenance support claims, both by spouses or incapable adults, minor children, all of that. And really, it comes down to, as a provider or a parent, you have a legal and moral obligation to your spouse. They have a reasonable expectation that you're going to provide for them when you die. And if you fail to do that, the court will fix it if they make that application. In those instances, it's important to act fairly quickly upon getting notice. You have a limited period of time, 6 months after the issuance of the grant of probate or the grant of the grant of probate to do that. And you need to act quickly, but that would be an instance where if someone was left out of the will and the deceased had a legal and moral obligation to provide for them, that they could wedge their way in. The other common challenge you see to a will is on the basis of validity of the will for various reasons, either technical defects or otherwise, or especially with elderly testators, based on the incapacity of the testator. So if they don't have the capacity to make a will, then you would have a situation where it would default to the previous will. And hopefully in that instance, if there's 3 kids, then they would have been provided for equally, which is generally how people do their estate planning, providing for their children equally or the grandchildren, and specific bequests after that. Specific bequests before that. But in that instance, if there's evidence of incapacity and suspicion of incapacity, people will challenge wills. We see enough situations where a family member may isolate an elderly person, cloister them from the rest of their family, and then all of a sudden, lo and behold, when grandpa dies, there's this nephew who gets everything and nobody else gets anything, right? That would be a suspicious circumstance where it would be warranted for a family member to perhaps challenge the validity of that will, especially if there are concerns about the old guy's ability to understand what he was doing when he made the will and appreciate what his property was.
Yeah, for sure. Quite often, people will name one of their RSP a direct beneficiary, but they'll forget about the tax implications involved. So let's say that a father leaves his son a $300,000 RSP, names the son as a designated beneficiary, but doesn't allow funds in the estate to pay the taxes on those registered funds. What authority does the executor have to go after the son in order to get the funds to pay the taxes?
Okay, there's a few things there. So there's a few different ways that you can designate beneficiaries. I generally encourage people to make that designation directly with whoever you hold your plan or your funds. Mm-hmm. If I have my RSP with CIBC, I say, this all goes to my son, and that transfers outside of your estate. So that would be property that falls outside of your estate. That's a lot cleaner. Especially if you're concerned about there being issues down the road. That same type of designation outside of your estate to your spouse, for example, results in a tax-free rollover, as long as it's done promptly. Some people, though, will designate their RRSPs, for example, to their estate, and that can create a host of problems. Mm-hmm. Then you can see these unintended tax implications, but in that instance, then the taxes are the estate's taxes to deal with. If you have a beneficiary designation within the will, I guess hypothetically, let's say to the son, if it says I'm leaving Johnny my RRSP, then if there's tax implications, those are his to deal with.
Okay.
Yeah, and those shouldn't be the responsibility of the estate.
Right. Okay. What about a situation where the spouses have wills, but they're killed in a car accident? What happens in that situation? Like, and like, I guess what I'm asking, Paul, is who ends up with the funds? And let's say that they don't have any children.
Yep.
Do the funds or do their estates end up on the husband's side or the wife's side, or what happens in that situation?
Okay, we've actually dealt with this exact situation, and it used to be that the oldest person who died in a common accident was deemed to have died first. So if the husband was older than the wife, then the wife's estate would get everything, and vice versa. But that's changed. Now they are both deemed under the legislation to have predeceased one another. So, which just leaves everything in their individual estates. So then you would use it. Sorry, in this situation, did you say they had a will or no will?
Let's say they had a will.
Okay, they had a will. Then it would just follow the terms of their will. In all likelihood, they would have left, everything to one another. And then if the other one wasn't there, it would go to whomever they decide, whoever they appoint after that. So their brothers and sisters in this situation, because you said there were no children. But it would go into their respective to the respective beneficiaries under their will. So there wouldn't be a transfer from one side to the other, which I think is that is the way it would have happened in the past, but that has since been changed.
Okay, so let's say that the wife named her siblings in the will, but had left the residual aspect of her estate to her husband. Would that go to his side of the family or stay on her side?
No, because of what I had just spoken about, the fact that they're deemed to have predeceased one another.
Yeah.
What would happen there, and what should happen, and this all comes down to planning, is that you don't just appoint one residual beneficiary. You appoint alternates. So there's something, when it comes to planning, I leave, for example, I leave everything to my wife. If my wife predeceases me, it goes to my kids. If they predecease me, everything goes to my siblings. You want to make sure that you're always planning for contingencies. And it's very common, especially when dealing with estate planning professionals, that, as much as we can, we're trying to plan for the worst case scenario. We'll have the common accident clause in there that says, I may have listed 20 people in my will, but if they all die and I die, there's still somewhere else for it to go. And that, that might be the Red Cross, the Calgary Foundation, wherever, but you always have something to what if, and if, those 20 people die and those two, charities cease to exist, well, we've got bigger problems.
Right. Well, yeah, that makes a lot of sense. What about the case where it's a business owner? Business owner passes away, has no will. What can the employees of that business do in order to protect their own jobs or their paychecks?
So I'm currently dealing with that right now. So what happens in that instance? If, and I'm just going to go through both scenarios. If there's a will, the personal representatives of the estate then become directors and shareholders of that company. Okay. And it'll be up to them. If they're out of their depth, they can hire somebody to assist them. And if they're out of their depth, perhaps, in our situation right now, they're relying on key employees. So, the deceased may have been the owner and shareholder, but he certainly will have, his key employees that he would have relied upon. So, in the same way that the deceased owner would have been relying on those people to run the business, the director and shareholder, who's the personal representative who stepped into the deceased shoes for the time being, to make sure that the companies are still running, can just assume that role and rely on those key employees. If there's nobody who's stepping forward, let's say there's no will and there's no no descendants. There might be a case there that the employees could apply to the court for a limited grant of administration, to allow them to keep the operation running for a short period of time until something can be figured out. The legislation will provide that there's somebody out there. This is those stories you hear of somebody finding out they have a great uncle who died who left them $1 million. But there's a well thought out regime in the legislation that all but ensures that somebody will get something.
Okay. Yeah.
And it's just going to be a matter of finding that someone.
Right. Yeah. Do you, as part of your practice, do you deal with like buy-sell agreements and those, like, especially when it comes to a private corporation or a partnership? Does your law firm look after the legal aspect of buy-sell agreements?
Oh yes, we're full service, so we can do everything, and I think that's one of our strengths in terms of our wills and estates practice, is that we have a whole corporate floor that's there to assist us. So if we have ourselves an $80 million estate with all kinds of business interests, and and operations need to continue, and we're looking down the road at doing a share sale or selling assets or whatever the situation may be, we're certainly well positioned to be able to assist with that.
Okay, well, that's great.
Yeah.
Do you find a lot of business owners don't do that kind of planning with the buy-sell agreements?
It's important, and again, I can't harp on this enough, and I know planning isn't the bulk of what I do, but I do see the other side. I'm there for the autopsy. So the more you can do on this side of the ledger while you're alive, certainly you're going to position your estate and your beneficiaries to be in a much better position, and certainly to make sure that the assets that you've spent your life accumulating are there for their benefit. We often will involve tax planning and business succession discussions in all of our overall estate planning. It's important that that we have a holistic view of everything that's happening for our clients, so that we can understand what it is that they're doing and where they want to go with this, but just to make sure that they're also that they're protected in the event of their demise. It's just so important to look at it as a whole, I think, from our perspective.
Yeah, absolutely. You gotta think a lot of what if scenarios, I guess. So just a couple more questions, Paul. What about the situation where there's a mother, an elderly mother, and then 3 sons, and one of the sons has been granted power of attorney over his mother's estate or over his mother's financial affairs. He's also the executor. And in order to make things a little easier, he makes his mother's account joint with him. And then she passes away. And because the account is joint with right of survivorship, it becomes his account. What problems can arise in a situation like that? Like if what claim might the other beneficiaries have on that joint account if the brother who was power of attorney and executor says, "Oh no, mom wanted me to have those funds"?
Yeah, the first thing I'd say is, where's the gift letter? So that would be that's always important, right? The timing there that you've mentioned, it would be one thing if mom added him jointly prior to her loss of capacity. Then he might have a better claim. Although again, I would say the same thing. Where's the gift letter? Show me her intention to gift you that money. And oftentimes people will say things like, "Well, she transferred this into my name jointly." You say, "That's great. I don't see enough evidence there." What you would assert is a resulting trust. So, oftentimes elderly folks will put one of their kids on jointly with them to help them with their day-to-day banking. They're still functioning members of society with capacity and, living healthy happy lives. But maybe they just don't want to walk to the bank, or maybe they don't want to do this or that, or maybe their son's an accountant or some kind of professional who's very good at dealing with these things. But if the person's being added for purely administrative reasons, a claim to that being a gift would be very, very tenuous. The siblings challenging that would just have to say, show me the gift letter, show me her intention. What evidence do you have of that? And then that would result in the onus being on that person who's asserting that was a gift to prove that. So it's one of those shifting onus situations. Yeah.
Okay. All right. So a gift letter would be the best way to go.
If that's your intent, certainly get that gift letter. You'll want to have as much evidence as possible that this is your intention, if it is in fact your intention. Something more than simply the record at TD that says I'm transferring this into Susie's name or Johnny's name or whatever the situation may be.
And one final question that has to do with guardianship. So let's say that husband and wife, they've named their best friends, and let's say they're next door neighbors or their best friends as guardians of their two children. The parents are killed in a car accident. In their will, it says they want their friends, John and Mary, to look after the kids. But the grandparents take exception to this. Can the grandparents make a claim for guardianship of their grandchildren in that situation? Or what would happen? How would the court resolve that?
Yeah, so like I had said earlier, a person can always make a claim for anything. This scenario that you're describing underscores the importance of communication. And I know I've been harping on the importance of planning, but the importance of communication can't be understated either. People need to know what you're planning, especially family members who may be affected by those choices. If you're going to write somebody out of your will, tell everybody, mm-hmm. Right? Like, I mean, people often keep that stuff private, but if you have, an estranged son and you don't want to leave him anything, make sure that that's well known, especially amongst your family members, because then there's no surprises. And similarly, if you're going to decide that your neighbors are better equipped to look after your young children than your elderly parents, let your elderly parents know that too, so they're not taken aback or off guard. A determination of guardianship, especially with minor children, is always going to be based on what's in the child's best interest. So it's difficult to say how the court will rule one way or another. They'll want to respect the testator's intentions to the point that they can. But at the end of the day, the court is going to decide, we're going to do what's in the kid's best interest. So it would be a very fact-specific inquiry that the court would have to undertake there. However, again, back to the importance of communication. I think a lot of these disputes could be resolved if people weren't surprised by the content of the will or the content of the EPA or whatever document we may be talking about.
Right. Okay. Just in closing, do you have any other really unusual examples or cases you can tell us that our audience might find insightful?
People spend a lot of time and a lot of money. I was thinking about this in terms of, what's my gripe, or what's the most unusual thing that people tend to fight about. And I think the most inefficient thing that people tend to fight about is furniture, wine, and gold coins. And if I could ban gold coins, I would. They're a constant source of friction. I think there was a period of time where the baby boomer generation really started accumulating gold coins and had a lot of faith in gold. And I'm seeing a lot of gold coins these days, and they're always a source of dispute. But people spend a lot of time fighting about things that we don't think are really that important. And we end up with things like, ugly piggy banks or Christmas ornaments in our office under trust conditions, waiting for people to come to some kind of agreement as to how we should go about distributing those things. And I think if people, could step back and take some of the emotion out of it, they'd find that they'd get themselves to a clearer resolution and spend an awful lot less money, than that 2 months long dispute about which Christmas ornaments you want. It's just not a great use of time. I mean, we certainly see a lot of unusual things in this practice because we see so much of people's lives that may not be visible from the surface, but once you start looking at their life and putting everything together, I mean, you run into all manner of strange situations where you have second families and that kind of thing, or just long lost children that we didn't know about. Just stuff that you wouldn't imagine. But I think what really gets to me is these fights over small pieces of personal property. I think that's something that if you can plan for in your will and your estate planning, and give your executor the discretion to deal with that stuff as they wish, unfettered discretion to deal with those kind of small ticket items. And I don't think gold coins are necessarily a small ticket item, but when we're talking about Christmas ornaments and furniture and wine collections and that kind of thing, I think you just have to trust your executors because you're putting them there because of people that you're going to trust with the administration of your estate and your affairs.
Right. Yeah. So I guess, you talk a lot about communication, sitting down with your family members, talking about the estate. I guess that's probably the best route. Even though maybe the parents don't necessarily feel comfortable divulging all of their assets, they can talk about certain aspect or certain assets, just to kind of prevent disagreements in the future when they do pass away.
Certainly, and it's not typical. I wouldn't say in at least on the planning side of our practice, to list out everything you own. You don't typically say, I, Paul Reid, have $100 million and I'm distributing it like such, right? Yeah. You're simply saying, I'm going to distribute the value of my estate, a third amongst my children. And, Johnny gets this painting, Susie gets that painting, and he gets this old basketball or whatever it is. You may provide that information to your lawyer because it'll help them understand who you are and what your planning goals are. And it certainly will be useful background information if there's ever a challenge to your will. And I guess that's something that we're always doing on the back end that people may not see is and I think that's one of the most valuable aspects of going to a lawyer is that, what you don't see behind the will is this whole drafting solicitor's file, which is a lot of evidence demonstrating, the reasons for your intention. So, and providing evidence of your capacity to make a will, providing evidence of, perhaps any trouble that you may see down the road, which helps them understand how to better structure your estate planning documents. But the supporting evidence, I guess, that's there and available in the event that there's a will challenge is invaluable and certainly will help the testator's intentions be respected, I guess, at the end of the day.
Yeah, for sure. Okay, it looks like we're just about out of time. Thank you, Paul, for being our guest today and for providing some great insight and valuable information. It is very much appreciated. Paul, how can our audience get in touch with you?
So I can be reached at 403-298-9281 or by email at reid@carscallen.com. Thank you very much, Gary. I really appreciated being on your show. That was a lot of fun. Okay, well, thanks again. And I also want to thank our sponsor, Customplan Financial Advisors. Customplan Financial Advisors is an MGA, an award-winning MGA that provides support and resources to the independent financial advisor. Please visit their website at customplanfinancial.com. This podcast will be available on YouTube, Spotify,
and at financialpodcast.ca. To be notified directly when new podcasts are available, please visit financialpodcast.ca and sign up. If you have an idea or a topic or somebody who you think would make a great guest, please let us know at contact@financialpodcast.ca or info@financialpodcast.ca. Thank you, Paul, once again, and everybody have a great day.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.